Hello, I'm Philip Sales. In this video I'll be interviewing Lord Justice Etherton, who was Chairman of the Law Commission between 2006 and 2009. We'll be speaking about the role of the Law Commission in the legislative process. Lord Justice Etherton, what is the Law Commission?
The Law Commission is a permanent body set up to advise the government on simplifying the law, making it more cost effective and easier to understand, set up in 1965 as a non-departmental public body, which means that although it advises the government, it is at arm's length from it.
What was the reason for it being set up in 1965?
Well, the reason for it being set up, in a sense, is explained by what I've just said, which is that up until that time, there were various small committees set up from time to time to look at the law, to see which acts of Parliament were obsolete and should be repealed, which area of the laws were too complex, not modern enough, not cost effective enough, and it was thought appropriate to set up a permanent body which could look at these things, properly staffed, with proper communications to Parliament and to the Executive, to enable our laws to become easier to understand, more modern and more effective.
What's the legislation which governs the activities of the Commission?
That's the Law Commissions Act 1965, but it has been amended.
Who is on the Commission?
The statute provides for 5 commissioners, of whom one is the chair. The chair is now, by amendment of the 1965 Act, always a High Court judge or a Court of Appeal judge. I'll come back to that in a moment. The other 4 commissioners must be either judges or legal academics or practitioners, solicitors or barristers. So there are 5 commissioners altogether. The chair and the other 4 all head teams within the commission. And I mentioned the point about the chair being a judge, a very senior judge, either a High Court judge or a Court of Appeal judge, and that really symbolises both the importance of the Commission and its independence from the ordinary political life of the country in the sense of politics from day to day.
What functions are given to the Commission by statute?
The overriding obligation or responsibility of the Commission under the 1965 Act is to keep the law of England and Wales under review with a purpose of making it better law, effectively.
What staff does the Commission have to help in its tasks?
Well, I've already mentioned the chair and the 4 commissioners. I've explained that each of the commissioners heads a team which is reflective of an area of the law. So the 4 teams that they have at the moment are the criminal law team, the public law team, a team concerned with commercial and common law, and a team concerned with trusts, family and property law. Within each of those teams there will be a number of experienced lawyers. Those are people who've been in practice for some time or who have been academics for some time. And in addition, every year the Commission employs a number of young, usually young graduates who will stay for a year or 2 as research assistants. In addition to those, we have the ordinary support staff looking after the general organisation of the organisation. I should mention 2 other, teams, 2 other areas with which the Commission is concerned. One is the statute repeal team and consolidation team. That team is devoted to consolidating existing statutes where they can and to the repeal of obsolete statutes. The other area or team that I should mention also are our economists, because for the last 2 years now we have employed 1 senior and 2 junior economists in order to root the work of the Commission in an economic perspective, to make sure that the recommendations actually work in practice in terms of cost effectiveness, and also to ensure that they receive the best possible support from the government in terms of cost effectiveness.
Can you give us some examples of successes that the Commission has had in securing law reform through the statute book?
Well, what I should say overall is that since 1965 the Commission has provided reports which have led to new or partially new acts of Parliament in about 100 instances covering all different areas of the law. I'm not now talking about statutory instruments, but just looking at primary legislation. As I said, it's produced probably something like 200 or 200 plus reports leading to legislation in about 100 cases. And they cover all areas of the law: the Matrimonial Causes Act, for example, Land Registration Act, a whole host of criminal law provisions, the Criminal Justice Act 2003. Really, there isn't an area of our law which hasn't been affected in one way or another by the Law Commission.
How effective has the Commission been in the past in getting its reports and recommendations carried through to the statute book?
Well, as a very rough figure, we consider that in the region of 70% of our recommendations have been implemented in whole or in part. So that may be that they feature in only one or two sections of a much larger bill, or in some cases one of our reports is more or less implemented wholesale. But about 70% of our recommendations are accepted. The problem that the Commission encounters is that it's having to fight for legislative time and space at a time when they're competing with other departments or within departments for legislative time. And so what one tends to find is that the Commission publishes a report. That report will probably take 3 years or more to produce. And then it has to wait quite a long time to ensure implementation. But some of the proposals that we've been implemented recently are intended to rectify that defect, as it were, in the implementation stage.
So tell us a little bit more about the measures that have been taken recently to improve implementation of Law Commission reports.
Okay, well, there have been a number of significant developments very recently. Among the most important are the following. First of all, we have a new House of Lords procedure for certain, what are described as non-controversial or non-politically controversial Law Commission measures. So these are the types of things that appeal to the workaday lawyer, very important, but they're not politically of the first order. In the recent past, these would never have been implemented, frankly. They wouldn't have got legislative space. But under a new House of Lords procedure, where there are Law Commission recommendations which are thought to be highly desirable but not politically of great interest, there's a new procedure under which, if all the parties agree, the measure, Law Commission bill, based on the Law Commission recommendations, is introduced into the House of Lords. Instead of the second reading being on the floor of the House, thereby taking up legislative time, it's taken in committee. And then most important of all, at the committee stage, what's called the Special Public Bills Committee procedure is applied. So the committee is set up of a limited number of people with some particular interest, expertise, or political interest in the measure, and that committee can take evidence, and on the basis of its reading of the evidence and its deliberations, it can make amendments. And the idea is that with that expertise, against the background of a non-politically controversial measure, the third reading really should go through without almost any speeches of any kind, and then be implemented. The next matter that's arisen, which will help the Law Commission enormously, is the passing of the Law Commission Act 2009. This does two things. First of all, it imposes on the Lord Chancellor, who is the minister responsible for the Law Commission, it imposes on him or her the obligation to make a report to Parliament each year saying what the government's intentions are regarding outstanding Law Commission proposals. That will enable Parliament to hold the government to account for any unwanted failure to implement or consider the implementation of outstanding Law Commission recommendations. Also within the Law Commission Act is a provision for a protocol backed by statute governing the working relations between the Law Commission and the executive, that is the civil service. And this provides for a close working relationship and for the department, upon the publication or final publication of the Law Commission's recommendations, to give an interim response within 6 months and then a final response within 1 year, and to lend support to the successful implementation of the Law Commission recommendations.
How does the Commission decide what projects to undertake?
Well, the protocol now sets out the various criteria which are applied by the Law Commission, and there are now quite a few of them. But in broad terms, the following are the most important. First, you have to consider whether the proposal for reform is going to be of great or lesser or medium significance within the area of the law in question. You have to consider what the priorities are between different areas of the law, what most needs reform. You have to consider what are the resources of the Commission. That's not just financial resources, but also the personnel resources. Do we have the personnel capable of carrying out this particular project to its best effect? And then, very important of all, the Law Commission won't take on projects which are highly politically sensitive. There's no point in doing that. Their rationale is to look at the law in difficult areas which are not necessarily of political interest. That's not to say they never do any work that is of political interest, but if it's highly political, the Law Commission isn't the right body to doing so, because they're a group of legal experts, not political experts, looking at the law, intending to make it better for the ordinary citizen in the ordinary way of their lives.
Is the Commission ever told to take on a project by the government?
The government can't tell the Law Commission to take on a project. As I've explained, the status of the Law Commission is that of a non-departmental public body. So although it has to account for what it does, and it accounts to, as I've said, the Lord Chancellor, Secretary of State for Justice, for what it does, and it can only take on projects which have been approved by the Lord Chancellor. The reverse isn't true. That is to say, the Lord Chancellor can't require that the Law Commission takes on a project if the Law Commission simply doesn't think it's appropriate for it to do so. And what tends to happen before any project is taken on is that there's a very close association discussion between the Law Commission and the relevant department to see whether it's the sort of thing that the Law Commission can or should be doing, and whether it's the sort of thing that has a policy priority within the department.
Once the Commission decides to take on a project, what happens next?
Well, once it's decided to take on a project, it will usually, well, by the time it's got to that stage, it has already consulted very widely. It's consulted, as I've already indicated, with the relevant department and departmental officials concerned, but it also would have carried a much wider review of the area of the law. It will have done that internally. It will have had communications with academics, practitioners, anybody who's of real importance in the field. And at that point, it will decide to take it on. At that point, what then happens is very often now, the Law Commission will publish a scoping or discussion paper. That means it will issue, usually for general circulation, doesn't necessarily mean that might be a slightly small or confined circulation, but usually for general circulation, it will distribute the discussion paper to let everybody know within the relevant area of the law, that's practitioners, academics, politicians and others, that it's going to do a project in this area, and perhaps asking for comments about the proposed scope of the project, because it may be too wide, too small, and so on. What then happens is that once we have the results of the consultation from the scoping paper, is that the relevant team will get down to the task of producing a consultation paper. That again will involve widespread discussion, sometimes public seminars, obviously research of the law, the economists will be involved, all of those. And eventually it will publish a consultation paper which is done in every single case of a Law Commission project. All projects have at least one public consultation, and that's very important for the Law Commission to provide some credibility, public credibility, to its work. And then from there we go on to do the final report.